clear and convincing standard means that the evidence is highly and substantially more likely true than untrue when the court looks at the evidence that the state introduced today at today's hearing. State called as its witness Brooke Lundbaum. That was their only witness to meet their burden of proof. The only evidence they put in was Dr. Lundbaum. And Dr. Lundbaum has a long history with Ms. Geyser. As the court knows, Dr. Lundbaum's history with Ms. Geyser goes all the way back to when she did a competency evaluation very early on in the case before Ms. Geyser was adjudicated NGI. And Dr. Lundbaum, with that very long history, has conducted a number of evaluations and at least 2 conditional release reports, if not more. I think more than that, actually. And last time Dr. Lundbaum testified, the state called her last time as well to meet their burden of proof, she indicated that she did not support release. So what does the state do now in January of 2025? They call Dr. Lundbaum again. And now their witness takes the stand and testifies under oath that based on her deep analysis in this case, understanding the statutory criteria that needs to be considered, she cites it on page 1 of her opinion, the state's own witness testifies in support of conditional release. And I think almost everything Mr. Sapakowicz just said is a red herring to get this court to be scared somehow into doing what I think is the right thing to do and what the doctors believe is the right thing to do. We can never change the crime. It was a horrible event that took place, a horrible act that Ms. Geyser committed, that she recognizes was horrible. She's talked about it at such length with her therapists and counselors. It's been the theme of constant discussion, and we absolutely have no doubt in this history of this case that there were and was psychotic conditions that she exhibited that explains the behavior, no doubt. Now, and that's because there's a confluence of opinions, a unanimity of opinions among all the professionals who evaluated her in close proximity to this offense who agree on that. They agree on it because including Dr. Lundbaum and Collins and Robbins, because they've been a part of Ms. Geyser's life for over 10 years. And all of them agree, and the state's casting a broad brush here, but I think it's far more nuanced than the way they're characterizing it, frankly. We are dealing with childhood schizophrenia, which is, as every doctor has said, both in their reports and testified to at various times, it's a very difficult condition to precisely diagnose. And they did diagnose it, and they identified it. And there's no question that Ms. Geyser, as a result of those delusions and that trauma, committed this horrible crime. No doubt about it. I don't think the state stipulated to that when they agreed to the NGI finding. And it explains the behavior. The question becomes for this court today, when they attempt to meet their burden of proof, the question becomes whether they've shown by clear and convincing evidence that today, as you look at Ms. Geyser sitting here in court as an individual, whether she still presents that same risk today. She doesn't. She doesn't. Their own witness that they called explained why she doesn't. And what Dr. Lundbaum indicates is that the evidence does not continue to support that conclusion that she poses a risk of bodily harm to herself or others if conditionally released. She offers that opinion to a reasonable degree of professional certainty. Dr. Lundbaum notes that Morgan is 22. She comes to the court still committed to the Winnebago Mental Health Institute, and she describes how since 2021, there has been no attempt whatsoever for Ms. Geyser to injure herself. It was the last time, one and only time that there was any concern regarding her suicide attempt was October of 2021. And Dr. Lundbaum explains this isn't a situation where this is a wishy-washy doctor or somebody who's not confident or hasn't put a lot of thought or effort into their analysis. This is a doctor who explains exactly why she didn't support it in March, but supports it now. she explains that one concern she had back in March was that there was episodic display of heightened emotional distress in the absence of clear provocation or context. And there were concerns about trauma and intrusive memories. What she noted is that since the last petition, Ms. Geyser has been on the minimum security unit at the facility. She's been consistently placed in the pre-integration phase of treatment since June of 2022, which is the highest level of the highest level of permission available. She's earned all the privileges available to Winnebago mental health patients. She's acquired full escorted liberty privileges in February of 2024. She's participated in staff-supervised off-grounds activities since March of 2023. And all of the available information, she notes, Dr. Lundbaum notes, reflects that Ms. Geyser has demonstrated, quote, consistent rule compliance. Now contrast that just for a minute against Randall. I don't know the case. It was a big case in Waukesha County, as I understand it.
Well, it's still a big case, actually, across the state. But since we're citing it again, it's at 211 WSAP 102. That's the citation to it from 2011. But go ahead, just to put that in context.
It is a big case.
Yeah.
And what I meant by that remark was that it was a Waukesha County case specifically, as I understand it, historically. That was a very big case for the community, and it remains a published decision, as you know. But contrast what I just read in Ms. Geyser's behavior against Mr. Randall, who, while he was at Winnebago, the court noted, I think it was Judge Dreyfus who presided over the conditional release hearing, noted that while institutionalized, Randall was secretive, lied to staff, breaking rules when it situated him, and his behavior while committed mirrored the behavior that he exhibited in the community. And what Judge Dreyfus noted and the Court of Appeals emphasized in the published opinion that Your Honor cited was that Randall's secretive behavior throughout his years of commitment, throughout all those years that he was at Winnebago, included hiding items above ceiling tiles at a bicycle shop at Winnebago, denying that the items were his. The court noted that that was very similar behavior to what he exhibited during his original crime spree, because as I understand it, he engaged in a crime spree where he hid a CPR dummy above the ceiling tiles of a high school during a burglary. And when Randall was confronted about these things, he would become agitated and angry with the staff. The trial court made other findings about rule violations and inappropriate behavior throughout his time at Winnebago, failing to report to the treatment professionals that he had inherited money in a trailer, purchasing real estate for $42,000 with his inheritance without revealing that, hiding illicit items of property he purchased, receiving mail without the approval of his supervisors, maintaining a secret bank account, only revealing ownership interest in a property 14 months after he purchased it because he believed that he had been cheated out of $70,000, lying about turning over his keys to his property, lying to his supervisors about receiving mail about the property, violating conditions of his off-ground work privileges by going to his property in a restaurant without permission. And he was aware of all these rules. And it was based on those findings that were in the record that the state put in, that the court, that Judge Dreyfus could conclude reasonably that Mr. Randall was being devious, secretive, and essentially deciding he'll do the things he wishes to do regardless of the restrictions or limitations of Winnebago. And Randall himself didn't dispute the fact that he violated the rules on innumerable examples. He just argued they didn't matter. They're not significant enough because they don't involve violence. But what the court noted was you just keep breaking the rules, even when you're in the institution. So I think when you're examining whether they've met their burden of proof and they've called nobody from Winnebago to testify at all that Ms. Geyser has been anything other than an exemplary model patient, and our witnesses substantiate that fact and we don't have a burden of proof, it's far different, far different than the Randall case. Now, there is, of course, the principle in the Randall case that Your Honor cited last time, that if 3 doctors or the multitude of doctors support a particular conclusion, this court is vested with ultimate power and decision-making authority. Nobody's harboring any delusion about that fact, Randall's decision or not. But the question legally is whether they met their burden of proof by clear and convincing evidence. And what you have in this record here is an incredibly thoughtful and thorough opinion by Dr. Lundbaum, where she has examined that history at Winnebago with Ms. Geyser, which has been perfect. We know, and you have in personal knowledge, Your Honor, of Ms. Wyer's case, the co-defendant, you have personal knowledge in this situation of what happens in conditional release hearings, not just from that one, but from other cases you've presided over, and you know how the process works. Once the court approves conditional release, the facility will have 60 days to put together the plan with the treatment professionals in the community, WCS and DHS. And they'll put together a plan, and they will identify the group home for Ms. Geyser to live in. That's what they do for people who aren't going to go home to their parents. Put them in a group home. And you don't have to approve that. You can reject it. You can look at the plan they put together and say, I don't think a group home that they've identified is suitable, and I don't think these conditions make sense, and you can modify that or reject that as you see fit. But to trigger that process to occur requires you to grant conditional release. That's why this is so important. It's important because Ms. Geyser continues to demonstrate throughout her time at Winnebago consistent adherence to the rules of the facility. And as Dr. Lundbaum is noting, and as every doctor notes, and every person at Winnebago noted, that Ms. Geyser will be placed in a group home and supportive environment. She will be closely supervised by staff as she reintegrates into the community. And as you know from Ms. Wyer's case, there will be GPS monitoring. She'll be on a bracelet that will undoubtedly be ordered, and it'll be ordered so that Ms. Geyser's whereabouts are known 24/7. So that was the state's expert. The one witness they called to meet their burden of proof testified contrary to the arguments that they're now making, which is that Ms. Geyser should be essentially indefinitely detained in the facility, because it seems to me that none of these arguments will change. That Ms. Geyser herself has truly maximized the services available to her at Winnebago, and she's shown through her performance that she's not a risk. But it's not just Dr. Lundbaum. It's Dr. Robbins, who's the former director of Mendota, and I don't know who the experts were in the Randall case, but you do have to look at you do consider as part of this analysis who the experts are that are called to testify. There's different levels of doctors and professionals and caregivers in society. Some doctors are new, some are inexperienced, some don't do a thorough job, and then there's others that are immensely qualified. There's a wide range, just like there are of lawyers and other professionals. So last time we were here, 2 of the 3 doctors didn't support release, although Dr. Collins was close. She wanted to see additional positive progress by Ms. Geyser. Dr. Robbins, who is the second witness to testify, is the former director of the Mendota Mental Health Facility. And he evaluated Ms. Geyser, he studied the history, and he also supports release. He concludes that she's not a substantial risk to herself and others based on his study of the history. I think probably I hate to rank witnesses, but I think in terms of the length of the report, Dr. Collins' report was certainly the longest. You have personal familiarity with Dr. Collins in countless cases where she's appeared in front of Your Honor. And you do bring that to the table when you evaluate this situation. You consider your life experiences, you consider your history with Ms. Geyser, with the co-defendant, and also your familiarity with the doctors. Dr. Collins is the gold standard, if you will, of psychological evaluations. She has incredible experience, dozens of years working in this field. She runs behavioral consultants. She's the head of the Wisconsin Forensic Unit. This is a doctor who, by all accounts, I think even the state would agree, the state will frequently use Deborah Collins for its purposes. But Dr. Collins endorses Ms. Geyser's released a conditional release. When you read her report, I don't want to belabor it, but we went through it item by item, Your Honor, and Dr. Collins went through the full history of everything that's happened in this case. She went back through the competency evaluations, she went through the medical records, she read the summaries, she talked to the people at Winnebago, and she reached a conclusion that Ms. Geyser is no longer a substantial risk of violence to herself and others. Part of that is, as Ms. Nicolai pointed out when she called their first witness, there are some tests, the HCR test, for example, that they use to help shape their opinions. But it's also, Dr. Collins' opinion is also the product of her long history with Ms. Geyser, interacting with her, talking to her, working with her. And I thought it was significant that Dr. Collins talked about Ms. Geyser's incredible insight that she has into both why the crime happened, as well as what her needs are in the future.